Every year, thousands of asylum cases are won or lost on the quality of one document, the country expert witness report. A good report tells the tribunal that this person's story is consistent with the country they fled. A bad report tells the tribunal that the expert is not really an expert, or worse, that the expert is just an advocate dressed up in expert clothes. We have written, reviewed, and seen hundreds of expert reports across the United Kingdom, the United States, Canada, and the European Union. We have seen the same 15 mistakes over and over again. Some of these mistakes are simple, a missing paragraph, a wrong date. Others are structural. They sink the entire report. All of them can be avoided. Today, we walk through every one. If you are a lawyer instructing an expert, this is your quality checklist. If you are an aspiring expert, this is your way to make sure the tribunal actually uses your work. 15 mistakes, 5 groups, 1 checklist. Let us begin. You are watching the Human Rights Expert Witness channel. We are country expert witnesses based in London. We write expert reports for immigration tribunals in the United Kingdom, the United States, Canada, and the European Union. This video is part of our Lessons Learned series. We share what we have learned from years of practice, what works in front of tribunals, and what does not. We base this video on the legal framework. In the United Kingdom, the Civil Procedure Rules. Part 35, the Practice Direction of November 2024, and key case law including the Somalia decision from 2004, the Somalia Country Guidance case from 2014, the Somalia Tribunal decision from 2015, and the Pakistan Tribunal Authority from 2016. In the United States, Federal Rules of Evidence 702, the Dober Standard, and the Center for Gender and Refugee Studies Best Practice Guidance for Experts. All 15 mistakes are documented in published case law or in official guidance. None of them are theoretical. We have seen everyone in real reports. Before we look at the mistakes, you need to understand the stakes. In the United Kingdom, the upper tribunal ruled in the Somalia Tribunal decision from 2015 that failure to comply with the practice direction governing expert evidence, quote, affects the weight that will be given to an expert report. That means if your expert breaks the rules, even if the tribunal accepts the report into evidence, the judge can give it less weight. Less weight means less impact. Less impact often means the appeal is lost. In the United States, the rule is similar but stricter. Federal Rules of Evidence 702, interpreted through the Dober decision of 1993, requires that expert testimony be the product of reliable principles applied to the facts of the case. An expert whose methodology is not transparent or whose conclusions are not connected to evidence can be excluded entirely. The Center for Gender and Refugee Studies, which trains and supports country expert witnesses for United States immigration cases, has documented the same 15 mistakes that we will show you today. The rules are slightly different between countries. The mistakes are the same everywhere. Now let us walk through them, group by group. Group A, the basic structural mistakes. These are the easiest to fix, and yet they appear in almost every report that gets criticized by a tribunal. Mistake number 1, missing or incorrect statement of truth. The statement of truth is mandatory. Without it, the report is not technically an expert report at all. It is just a long opinion piece. In the United Kingdom, paragraph 9.4 of the practice direction sets out the exact wording required. In the United States, equivalent declarations are required under the relevant rules of procedure. How to avoid it. Copy the exact practice direction wording into every report. Add a separate duty declaration referencing the Somalia Country Guidance case from 2014, paragraphs 23 to 27. Sign with full name, credentials, and date. Use a wet signature scan, not a typed signature. Mistake number 2. Exceeding the 20-page limit without justification. The practice direction sets a 20-page maximum for the main body of the report. Curriculum vitae, appendices, and references do not count, but the actual analysis must fit in 20 pages. Reports that exceed this limit without a reasoned justification are commonly criticized by tribunals. How to avoid it. Plan the report length before writing. Move sources to endnotes, not in-text citations. Move biographical details and methodology notes to appendices. If you genuinely need more space, say for a very complex multi-issue case, explain the reason in the introduction. A reasoned exception is usually accepted. A silent 25-page wall of text is not. Mistake number 3. Not responding to the specific questions in the letter of instructions. The letter of instructions sets out what the lawyer is asking the expert to address. Some experts ignore the questions and write a generic report on the country. Tribunals notice. If the questions were, is this person at risk because of their ethnicity? And the report instead gives a general overview of the country, the report has not actually answered anything. How to avoid it? Treat the letter of instructions as a contract. List every question at the start of the analysis section. Address every question explicitly, even if briefly, to say, this is outside my expertise. Use the same numbering as the letter. If a question is unclear, write back to the lawyer and clarify before drafting. Group B. The mistakes that disqualify the expert before the report is even read. These are about who you are, what you have done, and what you have read. Mistake number 4. Not demonstrating prerequisite knowledge and qualifications. Some experts call themselves experts, but the curriculum vitae shows no relevant background, no published work on the country, no field work. The tribunal in the Somalia decision from 2004 said it directly. It is not enough for someone to merely assert that they are an expert. The expert had never visited the country, had not worked directly with the minority group he was writing about, and provided no first source evidence. The tribunal rejected the report. How to avoid it? Attach a detailed curriculum vitae to every report. List academic qualifications, publications, fieldwork, language skills, years of engagement with the country. If you are new to a topic, say so honestly. Co-author with someone more senior. Better a short, accurate curriculum vitae than a long, padded one. Mistake number 5. Not interviewing the client when nationality or ethnicity is disputed. If the case turns on whether the applicant is really from country X or really belongs to minority Y, an expert who has not interviewed the applicant has very little to offer. Yet some experts write nationality assessments based only on the lawyer's case summary. Tribunals see through this immediately. How to avoid it? When nationality or ethnicity is disputed, always interview the client directly by video link if you cannot meet in person. Test language fluency, regional dialects, knowledge of local geography, religious practices, family naming conventions. Document what you tested and what you found. Be explicit about the limits. Language analysis is not a perfect science, and your conclusions should reflect that. Mistake number 6. Not reading the Somalia country guidance case and not declaring you have read it. The Somalia country guidance case from 2014 sets out the 7 duties of an expert witness in immigration cases at paragraphs 23 to 27. The Pakistan Tribunal Authority from 2016, paragraph 69, made it explicit. Every expert report must declare that the expert has read this case and complies with the duties. The 7 duties are: first, provide opinion uninfluenced by the pressures of litigation. Second, be objective and unbiased. Third, never assume the role of an advocate. Fourth, state the facts and assumptions on which the opinion is based, without omitting material facts that detract. Fifth, make clear when a question falls outside the expert's expertise. Sixth, if the data is insufficient, state the opinion is provisional. Seventh, communicate any change of view through legal representatives. How to avoid it? Add a duty declaration at the end of every report, separate from the statement of truth, stating that you have read the Somalia country guidance case from 2014, paragraphs 23 to 27, and have complied with the 7 duties of an expert witness set out therein. This is non-negotiable. Group C. The mistakes that turn an expert opinion into unsupported speculation. Sources are the bridge between what you say and what the tribunal can verify. Mistake number 7. Not providing sufficient references, opinions without sources. Some reports contain bold claims with no source at all. The army targets ethnic minorities, says who? The police never investigate honor killings. Based on what? Tribunals call this bare assertion. In the Somalia decision from 2004, the tribunal rejected the report partly because the opinions had no underlying source or logic. How to avoid it? Every factual claim in the report should be footnoted to a primary source. Use the 3-tier source hierarchy. Tier 1. United Nations treaty bodies. The United Nations Refugee Agency. The United Nations Human Rights Office. Special rapporteurs. Tier 2. Government sources, including the United Kingdom Home Office country policy and information notes. Tier 3. Human Rights Watch, Amnesty International, Freedom House, Reporters Without Borders, academic research. If you cannot find a source for a claim, remove the claim. Mistake number 8. providing incorrect, outdated, or unverifiable references. Worse than no source is a wrong source. Citing a report that does not say what you claim it says. Citing a report that has been superseded by a newer edition. Citing a website that no longer exists without an archive copy. Tribunals and Home Office presenting officers check footnotes. If they catch one false citation, the entire report becomes suspect. How to avoid it? Use sources from the last 3 years where possible. Always check that quoted text actually exists in the cited document. Use the Internet Wayback Machine for any web sources to preserve the page as cited. Include direct quotation marks for verbatim text. If a key source is older than 3 years, explain why it is still relevant. Mistake number 9. Not declaring which facts are within own knowledge versus from sources. Paragraph 9.3, subparagraph F of the practice direction requires the expert to make clear which facts are within their own knowledge. For example, from fieldwork, from interviews they conducted, and which facts come from external sources. This distinction matters because the weight given to each is different. How to avoid it? Structure the report so that the country background section is clearly source-based with footnotes. Mark first-hand observations separately. For example, during fieldwork in this region in March 2025, I observed personally. Make the line visible to the reader. The statement of truth distinguishes between facts within knowledge, which you confirm to be true, and opinions, which you confirm to be your professional view. Group D. The mistakes that show the tribunal that the expert did not actually engage with this particular case. These mistakes turn a custom report into a copy-paste. Mistake number 10. Mistakes in the summary of the client's evidence. Wrong dates, wrong gender, wrong city of origin, mixing up family members. These mistakes, which look like simple typos, are devastating. They tell the tribunal that the expert did not read the bundle carefully. If the expert is careless with simple facts, why should the tribunal trust the analysis? How to avoid it? Read the entire bundle carefully before writing. List the applicant's basic facts at the start of the analysis section. Full name, date of birth, claimed nationality, ethnicity, religion, profession, family situation, journey route. Verify each fact against the witness statement and the screening interview. Have the report proofread by a colleague before submission. Mistake number 11. Use of generic paragraphs not specific to this case. Some experts reuse the same 5-page country overview in every report. The lawyer can see it. The Home Office can see it. The judge can see it. A generic country overview tells the tribunal that the report has not been written for this case. It has been assembled from a template. The probative value drops sharply. How to avoid it? Tailor every section to the case. If the applicant is from a specific city, talk about that city, not the country generally. If the applicant fears a specific armed group, address that group, not armed groups in general. Reuse research and source documents, but rewrite the analysis. The country background section should be no more than 20% of the report. The case-specific analysis should be the rest. Mistake number 12, not addressing internal relocation, and whether the applicant could safely live in another part of the country is one of the 3 questions the tribunal always asks. Reports that do not address it leave a major gap. The Home Office. Presenting officer will exploit that gap in cross-examination. How to avoid it? Always address internal relocation explicitly. List the major cities or regions of the country. For each, assess whether the persecutor has reached there, whether the applicant can survive economically, whether they have family or community support, and whether they would face discrimination on arrival. Use the reasonableness test, not just possible, but reasonable relocation. If relocation is not possible, explain exactly why. Group E, the mistakes that turn an expert into something else. These are the mistakes that the Court of Appeal and the upper tribunal warn about most directly. They are about who the expert is loyal to. Mistake number 13, overstepping into advocacy. The single most common criticism in published case law. The expert is not the lawyer. The expert does not argue that the applicant should win. The expert provides objective analysis. When the report says the appellant is credible, or the Home Office is wrong, or asylum should be granted, the expert has crossed the line. The Somalia Country Guidance case from 2014, paragraph 25, puts it directly, quote, the expert witness must never assume the role of an advocate. How to avoid it? Use neutral, analytical language. Say consistent with country information, plausible given current conditions, documented in the sources cited. In my professional opinion, based on the materials reviewed. Never say, I believe the applicant. The applicant is telling the truth. The Home Office is wrong. Asylum should succeed. Plausibility is for the expert. Credibility is for the judge. Mistake number 14. Including irrelevant material or emotive comment. Some experts pad reports with general human rights commentary, political views, emotional language about persecution, or statements about international law that are not connected to the specific facts of the case. This dilutes the analysis. It also exposes the expert to the criticism that they have a personal agenda. How to avoid it? Cut anything that does not directly support the analysis of this case. No general political commentary. No emotional adjectives about persecutors. No statements about whether the international community should do more. Stick to facts and conditions. The persecution speaks for itself when documented properly. Emotional language weakens, not strengthens, the report. Mistake number 15. Ignoring evidence that does not support the applicant's case. Some experts write as if the applicant's case has no weaknesses. The applicant said they were arrested in October, but the Home Office has a record of them leaving the country in September. The applicant claims their ethnicity is at high risk, but recent reports show conditions have improved. An expert who ignores these tensions and writes only the favorable analysis is exactly the informed advocate that the Somalia Tribunal decision from 2015 warns about. How to avoid it? Read the entire bundle, including documents that hurt the applicant's case. Address the tensions directly. Acknowledge inconsistencies. Explain, based on country evidence, why a tension might exist, for example, trauma, affecting recall, or common security practices in the country. The tribunal respects experts who acknowledge weaknesses honestly. Tribunals reject experts who pretend no weaknesses exist. If you are an immigration lawyer evaluating an expert report you have just received, go through these 15 points in order. If even one is failed seriously, raise it with the expert before filing. A good expert will revise. A serial expert who refuses to revise is the wrong expert for your case. If you are an expert finishing a draft, print this checklist. Go through it line by line. Every report you submit should pass every point. The first time you fail one of these in front of a tribunal, you risk your professional reputation. The second time, you may stop being instructed. The full checklist, together with the wording for the statement of truth, the duty declaration referencing the Somalia country guidance case from 2014, and templates for the most cited paragraphs, is available on our website. The link is in the description. 15 mistakes, 5 groups, 1 checklist, the rules behind them, the practice direction, the Somalia country guidance case from 2014, the Somalia Tribunal decision from 2015, the Pakistan Tribunal Authority from 2016, Federal Rules of Evidence 702, and the Dober Standard are published, freely available, and binding on every expert writing for an immigration tribunal. The reports that pass these 15 points are the reports that win cases. The reports that fail them are the reports that get quietly set aside by judges. Every lawyer who has been in this work for more than a year has seen both. Next in this series, what we have learned in years as expert witnesses, the cases that surprised us, the questions we have learned to ask, the line between assistance and advocacy. That is the next video. Subscribe to the channel. If you are a lawyer, save this video to share with new instructing solicitors. If you are an aspiring expert, watch every video in the Lessons Learned series. We will see you in the next one.